advisement. I will now call 126-479 in the matter of Leon J. Davis Jr. Respondent.
It please the court, Kathleen Seltzer-Lippert on behalf of the disciplinary administrator, present and ready for argument.
You may proceed.
This is an original action involving attorney discipline. Mr. Davis was licensed to practice law in Kansas in 20. Comes to the Supreme Court by way of summary submission, where the parties have agreed to the facts, rule violations, aggravating, mitigating factors, and a joint recommendation for a sanction. Highly summarize the basic factual background in this case. In December of 2019, Mr. Davis was arrested for DUI after employees at the Taco Bell drive-thru contacted law enforcement. In January of 2020, he was charged with felony DUI. He has an obligation to report felony charges. He did not report those felony charges as required within 14 days. The disciplinary administrator's office learned of the felony charges about a year and a half later when the prosecutor's office provided that information to our office. Subsequent to that, he did provide a written response with the assistance of counsel. He entered a plea to the felony DUI on November 17th of 2022. He did report that appropriately within the 14 days. On December 5th, 2022, this court entered a temporary suspension based on his felony conviction pursuant to Rule 219 G1. And then subsequent to that, the parties entered into the summary submission agreement, agreeing to rule violations, aggravating and mitigating factors, and a joint recommendation. With respect to the joint recommendation, it is the party's request of this court that temporary suspension be lifted, and then after it's lifted, would impose a 2-year suspension, but stay that suspension and place him on 2 years or 24 months of probation.
Can I just jump in here and ask the question that's on my mind, which is earlier this morning, we had a case in which a lawyer had a disorganized practice and had failed to follow up on some cases and failed to prepare a client accordingly. And your office asked for a 3-year suspension to be stayed. And now we have a felony DUI that's not reported. We're asking for a 2-year suspension. So help me square that circle.
Sure. I'm not familiar enough to speak to the previous case, but I can certainly speak to this case and the thought process that went into this recommendation. So the ABA standards certainly talk about when conduct is knowing that a suspension is appropriate. And the term of that suspension depends on a variety of factors, aggravating, mitigating factors, and of course the specific facts in the case. A couple of cases, I guess, in reviewing and looking at this case, I think are helpful. In 2019, the Henry Cure case, which is 309 Kansas 877, this court looked at a number of felony DUI cases. The facts are a little bit different in each one because each one is unique and individual, but clearly this court noted that felony DUI is a serious violation of the attorney's primary duty to the court, the bar, and erodes public confidence in the judicial system. And this court also noted that varying sanctions imposed are based on a careful consideration of aggravating and mitigating factors in this case. With respect to this situation, that's one of the, I guess, serious aggravating factors because it's 2 rule violations, which is noted in the aggravating factors that there are multiple violations. failure to report the felony charges. In fact, never reported the felony charges. It was reported by the prosecutor. And then, of course, the conduct, the felony DUI, driving while under the influence, which of course is dangerous to the public and so forth. So those are some of the aggravating factors. Also, in this particular case, the respondent, because he was temporarily suspended, he has been suspended for, it's coming up on a year. It's not quite a year. The temporary suspension was imposed December 5th of 2022. And so that is significant and I think important. The probation that was outlined, I think, is serious and creates the opportunity to go forward, affect the public, and to assist the respondent in making changes that are necessary so that rise again. Does that?
Thank you.
And another question I had in relation to just the summary agreement and past conduct, reportable conduct. By implication, a DUI, felony DUI infers, depending on which statutory scheme we're dealing with, 2 prior convictions for a DUI or a diversion and a conviction for a DUI in the past. What happened with those? Don't you have to report those too?
So there has been a change in the rules, and that partly explains it. So with respect to this case, and that's, I guess, as I will explain, I think that plays into the ultimate joint recommendation here. The respondent incurred a DUI in 2009, which was before he was licensed to practice law. He did disclose that on his bar application.
Thank you. Okay, I was wondering how far back we're going. And when was the other one?
Sure. The second DUI occurred in 2014. It was a second offense. I believe the plea was actually in 2015. And a DUI second is an A misdemeanor. Now the rules changed, I believe, January of 2021. And one of the rules that were modified in 2021, historically, at least since 2011, attorneys have been required to report when they're charged with a felony and or convicted of a felony. Prior to the rule change in 2021, there was not the requirement to report an A or a B misdemeanor charge or conviction. Subsequent to January of 2021, the rule was modified, and now there is a duty to report the A or B charges or conviction. But in 2014, 2015, when the respondent's DUI second occurred, that the specific requirement of reporting charges for A or B misdemeanor was not a requirement.
I appreciate the clarification. I didn't appreciate the history there because yeah, okay, thank you.
And I have a question. In paragraph 12 of the summary submission, the parties agree that respondent was under the mistaken belief that he was obligated to self-report only after he was convicted. So under the ABA standards, it's either intentional conduct or repeated negligent conduct. So would this be negligent conduct that wasn't repeated?
I would submit that knowing applies, although the parties didn't specifically agree. Knowingly certainly applies to the actual conduct of driving while under the influence. But I would reflect on—
But it was a separate, but you charged him with a separate violation for failing to report, correct?
Yes. So the separate violation is based on the former rule, Rule 203, subsection C, subsection 1, which required attorneys to report felony charges within 14 days. That rule, I believe, was effective or has been effective since 2011. The respondent was licensed in 2013, so it was effective prior to—
But I understand he violated the rule. The question is, did he violate that rule knowingly or negligently?
So as a licensed attorney, you have a duty to know the rules of professional conduct. And the rule it didn't change midstream for him. It was actually in effect before he was licensed as an attorney. So the joint recommendation, placing him on 24 months probation, or impose lift the temporary suspension, impose 2 years, place him on 24 months probation. The respondent did file, as required in 227F, a affidavit of compliance thus far with his probation terms. He provided our office with information supporting his compliance with the probation that he's able, with the probation terms that he's able to comply with, because the probation terms contemplate that he would come back to practice and require monitoring and supervision of the practice and some other terms. But with respect to his treatment and compliance with treatment and evaluations and abstinence, he has complied with those terms.
When did that begin? When did the compliance begin? How long has that been?
I want to
so
say
far?
April of 2023. It was, I think, the same date that the summary submission was submitted. I believe that's April 24th, but I may have the exact day wrong, but April of 2023. I would.
Thank you.
May it please the court. I'm Trey Petlin. I'm here with Leon Davis, the respondent in this case. On December 18, 2019, my client arrived at a crossroads. Unfortunately, he reached this crossroads in a Lincoln while he was driving while impaired. Back then, he was a functioning alcoholic. Somehow his practice was not affected. He wasn't missing hearings. He wasn't neglecting clients, but he certainly was teetering on the edge of becoming a non-functioning alcoholic. Michael Balancio, who's my client's KLAP monitor and his practice supervisor, reached out to me yesterday. He had written he was sorry he could not be here today. He wrote I think, a insightful letter, which was Respondent's Exhibit E1. When I began reading that letter, my first reaction was, whose side are you on? But he certainly wasn't immediately convinced that my client was invested or that he would succeed. And it was clear from the letter that he was not going to give my client a free pass. Davis was going to have to, in fact, change his life. I haven't read Mr. Balancio's letter. There is a happy ending. He describes my client's transformation as miraculous. Mr. Davis dove headfirst into AA. He found a group that included several lawyers, including lawyers who did criminal defense, that were there to mentor him and help him. He's been meeting with them frequently, much more than the probation would require, initially several times a week. He rose to be the vice president, and he's currently serving as vice president of his chapter. It's a 2-year term. Over the nearly 4 years that Mr. Davis has arrived at that crossroads, he has redefined that time in his life as rock bottom. That'll obviously be a lifelong challenge, but he has, to this point, made that his rock bottom. He's been on supervision and monitored for alcohol use since January 15 of 2020. He's been monitored through pretrial supervision, regular meetings with his pretrial supervision officer prior to his conviction, random urinalyses, remote breath unit, which was a condition of his bond for a while. And during house arrest, 2,160 hours of house arrest, he had daily phone calls for random UAs. And he did not have a single non-compliance. His substance abuse evaluation, which is Respondent's Exhibit C, goes into some of his background. He served in the Navy. He went combat zones twice. The evaluation identifies a couple points that I think are not unusual, but that are notable for our purposes. Number one, prior to my client's third DUI, he did not think he was a alcoholic. Thought he had bad luck. And Mr. Davis, like I think just about everybody on planet Earth, has had tragedy in his life, but he coped with his tragedy and his anxiety, even his anxiety related to the practice of law, with alcohol. Became a daily drinker. Mr. Davis enrolled in substance abuse treatment and mental health treatment to address grief, to address the triggers, to address anxiety, but also substance abuse issues specifically. He entered into a KLAP agreement in June of 2020. Renewed that agreement February of 2023. He formally accepted responsibility for his actions in his criminal case November 17 of 2022. He was sentenced, that's Exhibit M, Respondent's Exhibit M, on February 21 of 2020. Since the incident back in December of 2019, he's arrived at some milestones as a result of his sobriety. He has completed 3 full marathons and 6 half marathons. On October 21 of this year, he ran a marathon in 4 hours and 39 minutes, which was, he took an hour off of his time from 2021. So it's amazing what Mr. Davis can accomplish when he's not drinking. As of December 5, he will have his Ms. Seltzer-Lippert pointed out, he'll have 1 year of suspension. So this morning, I'm asking the court, I'm joining her office and recommending a 2-year suspension, stayed to give him an opportunity to complete 2 years of probation. Mr. Davis would like to address the court just briefly.
Morning, Leon Davis. I am the respondent in this case. I wanted to start off by just thanking everyone that's helped me through this process. Been a tough process, but you know, it was necessary. And my family, my friends, my colleagues, Trey, my lawyer, everyone has just done so many amazing things and showed me the support that I have and what I can do when I'm not drinking. And I'm just so happy to be here today to talk about being sober and being healthy and about trying to refocus my energies on something more constructive. I mean, I'm so sorry. There's not even words that can really state how sorry I am for all of these actions. It's not becoming of an attorney, and it's certainly not something that I want to be known for. I'm very, very grateful, you know, for this process. I understand why we need to have lawyers that are healthy, that are out there doing things for the public. And I'm asking, put some trust in me and to earn the privilege back someday. I don't know when it's going to happen, but I want to earn the privilege back to be a lawyer. It's not my right, it's a privilege. And I hope that by continuing these meetings, continuing to run, take care of myself, I know that I can be healthy, that I can be there for my clients. I genuinely care about them. And it's very difficult not being able to represent them in court, especially for decisions that are choices that I made. So I'm so thankful for the process, for the consideration that you all give to our requests. And I hope that one day that I can be a Kansas attorney.
I would waive rebuttal unless there are questions.
The court will take this matter under advisement. Thank you.